just as every section of the community has justice needs, and the business class has a certain justice need. And what kind of a justice need it is? One, expedition, as much as possible clarity and lack of uncertainty in both the law and the practice of law, and all facilitating other ancillary instruments, whether by state or by other instruments, which will advance the purpose of the justice needs of doing business. So given that, the question which is uppermost in the mind of, let's say, in the context of electronic method of transaction is, how best will it serve our justice needs? So whenever somebody enters into a transaction, the first question is, will I escape going into the clutches of litigation? Will there be a dispute? And if there is a dispute, how do I avoid it? So as much care and caution and attention you pay even to a drafting of a contract, we still find there are concerns which the drafting cannot avoid. People still land into litigation, and then courts struggle with finding answers. I just give you the context of this, switching over from a paper, a telegraph to a from a paper to a telegraph medium. I'll read from a judgment of the New York Court in 1869. It reads very, very interesting. So when a quote, so when a contract is made by telegraph, which must be in writing by the statute of frauds, if the parties authorize their agents either in writing or by parole to make a proposition in one side, the other party accepts it to the telegraph, that constitutes a contract in writing under the statute of frauds, because each party authorizes the agents, the company, or the company's operator to write for him. And it makes no difference whether that operator writes the offer or the acceptance in the presence of the principal and by his express direction with a steel pen an inch long attached to an ordinary pen holder, or whether his pen be a copper wire 1,000 miles long. So we are now beyond the copper wire age. We are in a different age. Therefore, when distances have been virtually obliterated and technology has given us this kind of boon as to be able to communicate, this kind of facility which we did not have earlier, I think, therefore, if the law is able to deal with some of those lingering concerns, you put it like this. So I'll give you a quick look at some of the cases which come post 1900, the model ancestral law. I'll just give you a couple of cases. For instance, what happened in Australia. This case was, there were three directors in a company. There were two companies, a director in one company A and three directors in company B. So in the second company, one of the directors asked the other directors to engage a particular e-signatory process so that they can sign the documents without being physically present all the time. So at a later point of time, this second director in the second company had engaged into a particular transaction with a credit trading facility, the third company. So the third company sued this company, and then one of the directors said, look here, I'm not party to a contract at all. And the question was whether it is attributable to him or whether the e-signature in the process, initiated by the second director, etc. The court took a very careful stand. If there is a scope for avoiding a liability by saying, taking a stand that will weaken the transaction processes and throwing doubts on the transaction processes, I think we must look at it. Therefore, if there is a possibility for throwing doubts on the transaction process, let us examine it. Now, today, that age is, I think, probably we have even crossed that age. The amendment to the Information Technology Act, with all the built-in intrinsic capacity to avoid all these perils. So just by way of contrast, let us look at a paper transaction. A paper transaction, if there is a dispute about whether somebody has signed or not, a contract being executed in a particular way or not, whether witnesses have signed, attested or not, we all get into an external evidence, pursuit process. So a handwriting expert comes in, a forensic science, dimension comes in. I think by one good stroke of pen, by bringing in an integrity to the transaction to the electronic mode and reasonable certainty in the electronic mode, we have done away with the external proof elements. So whatever proof is required to be stated about whether a transaction has taken place or not, that proof is built in intrinsically into the system itself. I think there's a very great advantage, a significant advantage. So when you talk about an arbitral process, don't you think there is a good takeaway from this? That if an external evidence and pursuit of external evidence leading to all kinds of time consumption, so on and so forth, is by one good stroke of pen said no. So the arbitral process greatly benefited by these intrinsic built-in elements of proof, evidence, etc. I think that's a very important development. Notwithstanding all this, for instance, there are few cases from an employer, whether an employee has been really engaged or not. Question is whether in the actual signing or the e-signing of a contract of employment, was his attention drawn to a particular clause which may negate the liability of an employer in certain circumstances. So the court said, in a California court said, if there is scope for any evidence being brought in about this negation of liability of an employer, I think we can still look at it. So these are those areas where the scope for negation of a liability under a contract, howsoever properly and duly it has been executed, maybe those areas where courts may still come in, an arbitrator may still look in. But I don't think these are areas which will create a great amount of uncertainty in the adjudicatory or the arbitral process. I think it's important to notice developments. And as Paul mentioned, most importantly in the Uncital model law, the functionally equivalent approach, by and large, I think has been taken care of across the globe. You look at the corpus of international law on e-contracting, e-transactions, using electronic method, and then dealing with authentications and so on and so forth, you find the functional approach is also built into it. Maybe we need to take a few more steps as to eliminate some of those unforeseen dimensions that may still crop up. After all, we know law is always ready to look at those unforeseen dimensions that crop up at any point of time. So having said that, I would probably like to the panelists to take over, but I just want to say that when you discuss in the context of an electronic mode of a transaction, the three factors, namely identification, attribution, and proof of assent. I think depending upon the nature of a contract, these three dimensions may have a different aspect or relevance. So I think probably we'll address that. Then I just go back again in point of time to say how technology has made all this little obsolete. I had a book published in the year 1990 on e-commerce. I just picked up a few pages of the book. I find that these were the apprehensions at that point of time. Because we have now traveled over history in more than 20 years, they created a couple of state lines and an instance given there.